The following program is for informational and educational purposes only. It is not to be considered legal advice. Fraudsters Radio was created to expose the many scams and frauds that have so infected society today. Scammers, fraudsters, and rip-off artists abound, whether it's scamming homeowners with bogus foreclosure relief services, dating fraud, incompetent lawyers, or consumer rip-offs. It's high time the public has a voice. If you work in a profession that deals with fraud, or if you believe you were or are a victim of fraud, you now have a radio-listening public that wants to hear from you. Please feel free to message us through our Fraudsters Radio Facebook page, and we may have you on the show as a guest. If you'd like to call in for today's show, the number is 646-668-8512.
And welcome to Fraudsters Radio. I'm Lori Z., nationally syndicated radio host and consumer advocate, along with my co-host, Storm Bradford, owner of Mortgage Fraud Examiners. And Storm, I think we're going to have a really good show today. Let's find out, how was your weekend?
My weekend was fine. How about yours?
Mine was pretty good. You know, when you're older, I think you tend to like mellow more. It seems like I'm cleaning the house a lot, too. I don't know.
Well, I was shoveling snow. We got 10 inches of snow, so.
Oh, I guess I can't complain then, huh?
No, you cannot, because the weather down there was what?
Well, it was kind of cool in the 60s, but it did hit the 70s, and now it's going to cool down again to the 60s.
I feel sorry for you.
I know, you could tell. Believe it or not, I actually have a long-sleeve shirt on. I'm like the only one in Florida with a long-sleeve shirt on now. Everybody else is in shorts and T-shirts, so it's kind of funny. We're going to have a really good show today talking about legal malpractice a little bit in. And I wanted to share a story that someone told me, another possible topic for this show that we haven't covered yet are the work-from-home frauds, where people, find, I don't know if they find these companies online and they look like they're legitimate and, you're going to work from home doing whatever it is, and then the company is a scammer or isn't paying. So I think that would make for a good show, because I think a lot of people get hit with that. And I notice, like online, like on Facebook, I always see these companies or on emails saying, hey, there's a list of 10 companies, come work for us. I don't think people do their due diligence, though, in checking out the actual companies. And a lot of times the companies don't even put a company name. So, how do you know who you're working for and if they're really going to pay?
And, Laurie, as we've said so many times before, and our guests have said as well, it really comes down to doing your due diligence. I mean, you really have got to, again, it's the old adage, if it sounds too good to be true, it is. I mean, think about it. I've seen some of these things before. A mother makes $10,000 a month, typing letters at home and other kind of nonsense like that. I mean, if that was true, everybody'd be doing it.
Exactly. But, that's one where you look at it and I would go, $10,000 a month typing from home, that just couldn't be possible. But you see other ones, some of them may be legitimate. I know there are jobs from home where you can work for big companies, like Amazon, for example. Some of these companies will hire people from home to do their customer service. And those may be legitimate jobs, but I don't know if they're directly through the company or if it's brokered out through a third-party company. So I think before you work for any type of company like that, you have to know who it is you're actually working for. And I don't know that a lot of these companies like to disclose that, so that makes me really wary,
Well, the companies like Amazon and them where people work at home, and some of these hotel chains and travel companies and things like that, a lot of these people are salaried. A lot of them are commission-based. But, for these ones that, pay us X amount of dollars and we will show you how to make $10,000 a month, that's the ones.
That's a scam. Yeah, those are a scam. And, listen, even on LinkedIn, I see people, everybody is selling how to be a mentor, how to be a coach, how to be better in business, and blah, 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 blah. And there's so many of them out there. And I'm not saying that they're not legitimate. Everybody may write their own book. but it's almost, it makes you go, well, whose advice can you trust? And I think in that case, you kind of have to do a little research on that person to see if they're successful or not, or if they're utilizing their methods, and how similar is it to what you are trying to do for your business. But there's a lot of it out there, and I try to, glimpse through it all, and I just go, wow, this is overwhelming to try to see. Everybody's a coach and a mentor.
Well, it's sad, though, too, is that what makes it even tougher is you have, well, I don't know if you call them an organization or an entity or what, but you have places on the Internet like rip-off reports.
Right.
Rip-off reports, the guy who started it, I believe, had an altruistic reason for doing it, and that was to give a platform for people that had got screwed by a company. But over time, it became a place where competitors knew you could go to Rip-Off Report, file a complaint under an assumed name, don't even have to give your real name, be a total lie about a competitor, and you can't get it off. Rip-Off has been sued many times, and they've won every lawsuit because the courts came back and said, look, all they're doing is giving a platform for people to talk, when in fact it's a total. Self-Reports, for example, has an F rating with the Better Business Bureau, and there's companies out there with A ratings with the Better Business Bureau where people that never had a complaint ever, but people go to rip-off reports that are competitors and try to make them look bad. So that's tough on people, too, trying to get the real information.
Well, I think there's a way, though, that you can get it off. I think you can file like a John Doe lawsuit if you don't know who the person is and get it removed. Because I know another attorney who has done that kind of thing.
Yeah, but what they have to do is, and look, and it gets really expensive because they have to do discovery, and then they have to, they ask rip-off reports to supply the real names of these people. Well, rip-off report doesn't know the real name of the person. So, the problem.
Well,
it's very, very expensive.
Oh, I'm sure, but I mean, when you file a complaint, I know that you do have to sign in, and it does say to sign in with your real information. But how many people actually do that? I don't know. I don't know if they can track you down to your computer, to your server. I'm not that technical, but I'm assuming there's probably some way that they have of tracking where it's coming from.
They have these VPNs now that hide your IP address and all this other kind of stuff.
That's true.
So it's really, really tough. I think the easiest way to do it is to look at what they're selling and say, okay, does this make sense? If they're selling a service, does that service that they're selling, does that make sense? If it doesn't pass the reason, logic, and common sense test, trust me, it's not real.
Right. Well, there are other boards besides. I know there are other boards besides rip-off reports that I've seen. I think like Planet Feedback might be one where people can file complaints. And I'll tell you what I found effective. When I feel a company is not providing the service that I'm paying for, and I can't get through to that company. Most of these companies do have some type of a Facebook presence where you can either post directly online or you can send a message to that company. But the problem with that is that a lot of those go unanswered, and the companies don't seem to care. And I'm thinking in particular, like down here in Florida, we have two major cable companies. They're both terrible. They both have terrible service, terrible customer service. They make promises that they can't keep. You can complain to them all you want, and they really pretty much just get away with doing what they want. And years ago, a Federal Communications Commission complaint you could fill out online might actually help you. But nowadays, I'm not seeing, like when I've had to do that, I don't really see any response back anymore. It's like they don't care or they're overwhelmed and they have too many people. But, as a whole, I don't understand that corporate concepts, because I've worked for corporations years ago where, you're held to a very high level of being ethical and doing the right thing. And in the last 10, 20 years, it seems to have dropped off and nobody cares. And it's, a minimum wage person in a cubicle who just doesn't even want to be there. And, where it goes from there.
Yeah, it's really sad how things have transpired, because that's the problem nowadays. Not only do companies rarely have ethics anymore or values, a lot of human beings don't have ethics or values, and they just don't care. So it's really a sad state of affairs the way the country is going. But I think, again, the way to look at things, and I always try to explain to people, if it doesn't pass that reason, logic, and common sense test, it's probably not real. It's like the law. I tell people the law is based on reason, logic, and common sense. If somebody tells you that's the law and it doesn't pass that reason, logic, and common sense test, it probably isn't the law. So you should check into it a little further before you take anybody's advice that's telling you something's the law, which is a very popular thing for people to do, which I question all the time. I'll be talking to a company and they'll say, oh, well, the law says so-and-so and so-and-so. And I said, oh, yes, send me the law. Oh, well, I didn't mean to say law. I mean, it's our policy. Big difference. So ask the hard question and you might get the right answer.
Yeah, one of the interesting things I've started doing on customer service calls, because I know that they're going to make that announcement that they're recording the call, is typically I'll say, well, I hope you don't mind that I'm also going to record this call so that there are no misconceptions about what was said and that we can confirm everything up. That way there's no problem in the future. Now, I will tell you, I'm surprised. That does not work because they'll just hang up. But with a lot of big companies, if you're recording me, then I'm recording you. And that way we don't have, it can't be a he said, she said, because we both have a recording of what was actually said. And I don't know, that seems to put the people more on notice that I'm serious about resolving whatever the issue is.
And what does that tell you when a company hangs up when you tell them I'm recording you? Okay, that's fine. I'm recording you. Oh, well, no. No, you can't do that.
Well,
excuse me.
Right.
If you're going to do it, I'm going to do it.
Exactly. But, in dealing my credit consulting business and dealing with debt collectors or teaching clients to deal with debt collectors, they automatically hang up if you say I'm recording this call. So that already tells you that they have no intent of doing the right thing because none of them want to be recorded. And most debt collection practices are actually owned by attorneys. So I'm sure that they're given that advice. I used to know someone that worked for a debt collection company. Yes, he's an ex-felon, and it was the only thing he ever went to jail for, got himself out of trouble, but he, some of the stuff that he and I talked about that goes on, in there, that debt collectors hire ex-felons because typically they can't find regular jobs. But as a debt collector, they figure they're good. And so he worked at a firm where, and I don't know the name of the firm, where they had a specific person in a specific room, and that was the person that broke all the laws, threatening them, harassing them, doing all that kind of, bad stuff that would fall under the FDCPA or the FCCPA here. The problem is people I don't understand. It's like, I don't know, we don't know everything about everything, but if somebody's doing something to you or you don't know the answer, you can go online. Of course, you have to consider the source of what you're reading, and that's the other problem. People don't always look at the source. So, for example, if I'm looking up something medical, I'm going to go to the WebMD or Mayo Clinic. If I don't recognize where it's coming from, I don't know that it's legitimate. Well, that's unfortunately what you have to do nowadays. You got to do as much checking out as you possibly can.
Well, there's always people selling snake oil, and there's always people out there buying it.
Yeah, there are. But consumers or people just in general, I don't know if they just don't read enough or I don't know, or they just don't pay attention. But, mostly I worry, like my mother's older, I worry about the elderly people. Like my mother's been taken advantage of. Fortunately, I was able to stop something a couple times before it happened. But elderly people, they're not really familiar that much with how the computer works. So for them, the scammers already know that, and, that's how they get hit up. I know here in Florida there are heavier laws if you can catch the person, against them because, there's, I guess, like a senior law if you're scamming somebody. It weighs more or it's worth more.
Yeah, well, I tell you what, Sunday morning, if you go through the dial and you see some of these preachers for pay and some of the things that they're saying and how they're talking in false tongues, and I mean, I sit there and I laugh. I mean, I turned on one yesterday. And this guy, he's talking, and all of a sudden he goes, "Oh, I've spoken in tongues again. You need to send me money."
Oh my God!
And I said, "Is this?" Because when I turned it on, I said, "Is this a comedy show?" And it was real.
Yeah. Yep, you'd be surprised. What I found, like looking on YouTube, is the top 10 YouTubers that make the most money were all people who did what I would consider really stupid things, and they made the most money because people like stupid, whereas they don't tend to like smart as much. But on that note, I want to go to a commercial break. I also want to give a quick disclaimer because our next guest is an attorney, so he will not be giving legal advice. We're just going to be discussing some topics. So stay with us. We'll be right back.
Have you received a notice of foreclosure on your property? Do you suspect that you're involved in an unfair or fraudulent loan agreement? Are you looking for a way to save your home? Would you like to cut through all the misinformation and find out what really works? Would you like to learn strategies that the so-called gurus aren't aware of? If you answered yes to any of those questions, a professional team at Mortgage Fraud Examiners can assist you and your attorney with all of these things and more. Contract breaches, errors, statutory regulatory violations, fraudulent appraisals, and other fraudulent conduct cause most mortgages to be legally problematic. In fact, the Federal Deposit Insurance Corporation found that nearly 2,000 financial institutions they assessed received citations for significant compliance violations. They also examined appraisals and found out that of the 259 appraisals reviewed for accuracy, only 7 fully complied with professional standards. Call us at 844-920-7200. That's 844-920-7200. Mortgage Fraud Examiners, 844-920-7200.
Okay, we're back on AM FM 24/7 radio. The call-in number is area code 646-668-8512. And we have a special guest today, Robert A. Stines, an attorney down there in Florida. And he's going to be discussing malpractice today, which is a great topic. Legal malpractice, that is. Are you there, Robert?
Yeah, I'm here. Thanks for having me on the show.
Yeah, well, I'm glad to have you. Got a question for you. Which side of the fence are you on? Are you defending legal malpractice or going after attorneys that are committing legal malpractice?
So I have been defending attorneys for the last 9 years, which puts me in a weird position because I get lots of calls from consumers and clients who call me saying, hey, I have a potential legal malpractice claim. Can you refer me to the best plaintiff's attorney you know? Or they may even say, do you think it's worth my time? So I defend attorneys, but I've spoken to clients about these types of issues.
Well, I know Laurie has a question for you because she told me many times that she's looked for attorneys who are plaintiff's attorneys looking to go against attorneys that have committed malpractice. And she's told me there's not one living attorney in Florida that does that.
No, man.
Well, yeah, let me wait a minute. Let me respond to that, Storm, before Robert answers. Is what I said is when you look for a legal malpractice attorney, if you call them and you tell them the name of the firm or the name of the attorney, and you call a bunch of them and they've all gotten referral business from all of those other attorneys, that you're looking at, then it's a conflict of interest, and then you can't find an attorney. And I found that to be a common problem.
That's not surprising to me because, yeah, we're in a profession, and And attorneys help out other attorneys. There are but there are attorneys out there who make their living representing consumers who've been wronged by attorneys. And yes, there are some attorneys out there who specialize in suing other attorneys in legal malpractice cases.
There you go, Laurie. You got to dig into his Rolodex.
Yeah, it's a tough one. Well, I know Robert had kindly sent over some questions, and of course I always have a million questions, but one of the questions was, can you explain what the elements are for legal malpractice? What needs to be proven?
Yeah, so it's before you even start the analysis, I think you have to be aware that there's first of all two buckets. There's your typical ethical violation, where you're not filing a lawsuit against the attorney. You're filing a bar grievance, a bar complaint, and that goes to the Florida bar. Then you have your legal malpractice action, where you want to sue your attorney because your attorney has harmed you and has caused damages. And that's when you go into court. And when you're in a legal malpractice world, you have to ask yourself, okay, were you in a criminal case where you think your attorney messed up in a criminal situation, or was this a civil case where your attorney was supposed to, you had a personal injury attorney or a contracts attorney, and you think he messed up? So those are the two subcategories you're thinking about. And then you have your, was this a transactional attorney or a litigation attorney? But typically in any of those types of cases, you're asking yourself, okay, the elements are, did I employ the attorney? Did I retain him? Next element is, did he do something that a competent attorney would not have done or would have done, and he just didn't do it? So was there a breach of some sort? And the third thing is, did that breach cause me harm? So those are the three elements you're thinking about if you want to file a lawsuit against an attorney. In a criminal situation, there's a one added element. For someone who was in criminal court and they think that their attorney messed up, they actually have to prove they were innocent. And if it wasn't for their attorney, they wouldn't be in jail or they wouldn't have been fined. So that's what you have to think about before you sue an attorney.
Okay.
Now, also, you might want to explain too, Robert, about disgorgement of fees.
Right. So let's say you sue an attorney and you are successful. You can say, hey, the amount that I paid you, you need to pay that back, and that's in your element of damages, right? How have I been harmed by my attorney's malpractice? Or in a grievance complaint, when you're dealing with the Florida bar, and I don't handle ethical violations. There are other attorneys out there that defend attorneys in ethical violations before the Florida bar. I don't do that. But I've heard of if an attorney is charging an unreasonable rate or is doing something that they just shouldn't have done, possibly there can be a reimbursement of fees. Not sure how that works, but I've heard about it.
Yeah, because I know lots of times you may not have a full-fledged case for malpractice, but he may not have gone as far as he could have gone, or whatever the case may be, so you might be able to nail him to disgorgement of fees.
Yeah, and that complicates things where it's okay. What would have happened if the attorney didn't make an error or didn't mess up, and what did I pay for, right? I mean, I paid for a certain result and it didn't happen, so I should get back the money I paid.
Right. And Robert, you may want to explain, in order to basically win a legal malpractice case, in a lot of instances, it's, as you know, it's known as a case within a case.
Right.
You would have had to have shown you to win the underlying case in order to prevail on that on your malpractice claim.
Yes, and that's what makes legal malpractice cases so difficult, right? So the case within the case, and that goes to, did the attorney's error cause me harm, right? So here's an example. If you have a personal injury case, let's say you're in a car accident, and you hire an attorney, and in a car accident case, you have 4 years to file your lawsuit. And your attorney, for whatever reason, drops the ball and doesn't file that lawsuit. Your car accident case is now barred. You can't. It's done. At that point, you can possibly file a legal malpractice case against your attorney. Now, one of the defenses to that case is, well, yes, I missed the statute of limitations, but you wouldn't have gotten anything because it was your error that caused the accident. So it becomes a case within a case, because then you have to prove, you the client, have to prove that if the attorney hadn't missed the statute of limitations, this case would have went to trial and I would have gotten X amount of dollars. But because he didn't do that, I don't get X amount of dollars. So you have to try the underlying case. In my example, it's the car accident. You have to try that case, prove you would have won, and then prove that the attorney messed up. So that complicates legal malpractice. It also makes it expensive in some cases.
All right.
Yeah, now let me ask you on malpractice, hiring malpractice attorneys, whether it's from the plaintiff side or defendant side, is that typically a pricey case, cost-wise?
Well, on the plaintiff side, in Florida, a lot of attorneys will work on contingency. So you're already in the 30 to 40% range in contingency. On the defense side, what typically happens is that most attorneys in Florida, if not all, have errors and omissions insurance.
Sure. Right.
So the carrier, the attorney's carrier, will step in a lot of times and pay the attorney's fees. And if there is a judgment, let's say a judge or a jury says, yes, Mr. Attorney, you messed up, you need to pay the client, then the insurance carrier will step up sometimes and pay that as well. But on the cost side, just talking cost, not attorney fees, but cost, it can become pricey because of, depending on the type of case, you might have to do a lot more depositions. You may have to do a lot more document discovery. I mean, it can take up a lot of time, a lot of effort, and it can be a long case before you actually see or get your day in court.
Let me ask you, does the Florida bar require malpractice insurance for attorneys?
Last time I looked at this, I don't think it's a requirement. It's highly suggested, but I don't think you are violating a bar rule if you don't have insurance. It's just, hey, they say everyone should. But again, I could be wrong. Last time I looked at this was like 5 years ago.
Yeah, I don't think they do. But which brings another question. If somebody was going to sue your client and he has no malpractice insurance, then you're trying to, and this guy's pretty slick, and he's got everything in a trust, and he really doesn't own anything, your client's pretty safe.
Yeah, again, any plaintiff's attorney does this analysis, right? You can have a super case, and in any type of case, you can have a slam dunk case, but if the person you're suing doesn't have any money, well, correct, is it worth your time, and is it worth the attorney's time? So yeah, that's a part of the analysis. So what you'll see a lot of times, as is typical in any negligence case, is that the attorney will request from the other side a copy of the liability insurance to see how much, if this attorney has any insurance, and how much he has. Because let's say you think, I had my example, a car accident case, and a typical car accident case like this, I would have gotten $2 million. But the attorney you want to sue only has $100,000 in liability insurance. Well, what are you gonna get? And you're right. There are ways to protect assets under Florida. So that all plays into the analysis of how far do you want to take your case.
Right.
Got it. All right. Well, you know what? Let's do a quick break now. We come back. We got a lot more questions for you. So stay with us. Back in a moment.
There is a very high likelihood your mortgage contains an extensive error. At Mortgage Fraud Examiners, we know just how costly a missed opportunity can be. For almost 40 years, we have consulted, retained, and referred to by attorneys, lawyers, trial practitioners throughout the nation. Put another way, we are the trusted source for litigation support. A foreclosure is basically an allegation the homeowner breached the contract by failing to make timely payments. The contract is clear. The borrower promised they would make timely payments, and if they didn't, the lender could take the property. The only way to overcome the homeowner's breach is to show the lender breached first. Identify errors that would void the contract. Identify regulatory violations, identify appraisal fraud and other fraudulent contact, and the only way to find these wrongs is to thoroughly examine the whole mortgage transaction. This meticulous examination of your mortgage transaction and appraisal can identify legal defects that would make your mortgage unenforceable and entitle you to compensation or even free title to your property. Call us at 844-920-7200. Mortgage Fraud Examiners, that's 844-920-7200. 844-920-7200.
Okay, we're back on AM/FM 24/7 radio. The call-in number is 646-668-8512. And we have our special guest, Robert Stines, an attorney in Florida, who is an expert in defending attorneys who have alleged to have committed malpractice.
Hey, that word expert, there's a lot loaded in.
They don't allow that. They don't allow that here, Storm.
I love to say that because I've always said the experts said the world was flat. So, but
let's just say I've been doing it for a long time.
Yeah. Well, let me ask you, Robert, so people will know before they go out and they sue a client that could possibly be a client of yours. What's the statute of limitations in Florida to file a legal malpractice claim?
Yeah, that's a great question. So in Florida, it's 2 years. It's a fairly short compared to the 4 year for negligence and the 5 years for breach of contract. It's 2 years. But here's the issue when it comes on to the statute of limitations. You have to figure out when that clock starts ticking. So one of the concepts is once a client knows the attorney messed up and they know of the harm, that's when the clock starts ticking. Now, the interesting thing is that let's say you're in a litigation case. You hire an attorney. I'll use my example. It's a car auto case. You get to a jury, and you think your attorney messed up and you should have gotten more money, or for some reason you got zero. At that point, you can't sue your attorney yet. You have to appeal. You have to exhaust all your options before you can sue an attorney. And then the clock starts ticking. Once you exhaust all your options, then the clock starts ticking. Then you have 2 years to sue your attorney. And it can be tricky trying to figure out, okay, do I sue my attorney now, or do I wait another 2 months, or have I already passed the 2 years? So when you hire a plaintiff's attorney, you need to be very aware, hey, I think my attorney messed up a year and a half ago. Do I have a statute of limitations issue? So make sure you're aware of that. 2 years.
Yeah.
Got it. All right.
And what if well, I was going to ask a question now, and this would come back to the case within the case again, would be you have the case, you think your lawyer screwed up, and you should have won some money, but you don't appeal.
Yeah.
When does the clock start running? It runs after your limitations period for the appellate. Bring it to the appellate court, right?
But that's tricky. You got to be careful with that because there's a defense in Florida called abandonment. So if you had the option to appeal and you didn't appeal, a possible defense is, well, you abandoned the claim to begin with. So, right. I mean, the way the courts see this is that if you didn't think the case was strong enough to appeal, why are you suing your attorney? So you got to be very careful about if you waive the option to appeal. Yeah, you can wait. You can say, well, now that my time to appeal has passed, I can now sue my attorney. The attorney may come back and say, no, you abandoned that legal malpractice claim, so there is no claim to begin with. So be careful about that.
And that's where it comes back to that case within the case. Hey, wait a minute. You could have appealed it. You decided not to appeal it. Sorry, you lose. Bye.
Yeah. Yeah. And that becomes tricky because then you're in the middle of a case, you have an attorney, and it goes to a jury, and you think something happened, you think your attorney made a mistake that caused you harm, but you don't want to use your attorney to appeal. It becomes a very weird situation where you don't think your attorney is going to handle the appeal. You need to find another attorney to do it because you think the second attorney might do a better job. So it becomes very difficult for clients to figure out, okay, do I stick with this attorney and run through the entire process, then sue him, or do I go ahead and fire him, hire a second attorney to do the appeal, wait till that's done, and then I sue the first attorney? It puts clients in a very touchy situation.
Right. Did
All
I
right,
hear
well,
you
let me
say go ahead. I was just going to ask, did I hear Robert say that you do represent or you do not represent people who have been charged with ethics violations?
I do not. What happens typically is we pass that off or we refer it to someone else. Sometimes there's overlap, but we don't like to get involved in the ethical side. We stick with the legal malpractice side if there's an ethical violation, and sometimes it happens within the case where we hear about within the case they've also filed a bar complaint. We bring in another attorney for various reasons to handle the bar complaint side. So no, we don't do the bar complaint side.
It would appear that there would be a lot more clients on the ethics side than there would be on the malpractice side. Is that not true?
It would appear that way. I mean, there's 100,000 attorneys in Florida, and
right.
my partner is on one of the grievance committees, and she says they have a pretty full deck.
Sure.
So yeah. But no, I only do the legal malpractice.
Yeah, and I want to bring up while you're talking about that, Storm, I actually pulled some statistics from the Florida Bar. Just to give you an idea, now 2017-18, it says there's 106,095 attorneys. And then it gives a whole bunch of numbers for total disbarments, suspensions, public reprimands, disciplinary revocation, total admonishments, total probations, injunctions. Okay, and the final it comes down to is there were 3,976 files open. 419 of them became cases, and only 275 of them became discipline orders. So, and that's actually considerably down from the 2013 to 2014 time. Those numbers for files, opened cases, and discipline orders has gone down. But I think a lot of people are afraid because they don't know. And maybe Robert, you can talk about how do you know if your attorney did something that would trigger a legal malpractice claim?
Right. So we're talking about the bar grievance versus legal malpractice. So typically in a legal malpractice claim, sometimes you just don't know, but sometimes it's pretty obvious. Like, hey, they missed the statute of limitations. They should have filed my car auto claim within 4 years. They didn't do it. I don't have a case anymore. If you're in a situation where you are barred from the court because of something your attorney did, yeah, you probably can start thinking, is there a possible legal malpractice claim here? Now, if your attorney made an error in judgment, civil cases, criminal cases, nothing is guaranteed. And any attorney who guarantees an outcome in a litigation case is playing a very risky game because you just never know. But if an attorney makes an error in judgment, it might be legal malpractice, it might not. That's something where you have to talk to a plaintiff attorney who can make that decision. Now, when it comes on to the ethical side, if your attorney, you hear about this all the time, if they mismanage their trust account, if they promise to give you a check within a certain amount of time frame, like let's say they settled the case and they said, hey, we'll have a check out to you, and that check doesn't arrive, yeah, you have a bar grievance. Or if your attorney just falls off the face of the earth and stops talking to you, yeah, you may have a bar grievance. So there are some obvious ones, and then there are some ones where you're in the gray area, and you have to really decide, was I harmed because of something my attorney did, and would someone else have done something better?
Okay, got it. And so, like, what areas of the law have the most legal malpractice cases? Is it usually like a specific, practice, type of practice?
Well, it's funny because insurance companies, like I said, they get involved in cases a lot. So insurance companies have put out statistics on these types of claims, and based on the type of practice you're in, you may see your rates go up because you're in a risky practice that sees a lot of legal malpractice claims, or you're in a practice where you rarely see legal malpractice claims. So when I speak to insurance carriers, they say that personal injury and real estate are the two practices that see the most legal malpractice claims. Now, that might be because personal injury is a volume practice. You know, there's a lot more personal injury claims out there, so you see a lot more legal malpractice. In the real estate world, it's just, a simple error on the documents or for whatever reason can really mess up a real estate deal. So you see a lot of real estate legal malpractice claims. On the grievance side, you see a lot more criminal grievances and family grievances. And the thought process behind that is because those types of cases are very emotional, and your attorney doing or saying something causes an emotional reaction that triggers a bar complaint. So I don't do the stats, but that's what I've heard.
Well, I think, attorneys as a rule kind of have a tough job because, if you're a litigator and you're representing someone and you win, the client says, "Oh, I should have won anyway." If you lose, you're a bad attorney.
Yes.
And so you really can't win, and that's where a lot of these grievances come from, is that, I had a slam dunk case. I really didn't need an attorney. I could have done this myself. And then if you lose, he was a slug. He didn't know what he was doing. I should have won the case. So, it's kind of tough, judging whether somebody has done something that is reprehensible or someone that is just mad because they may have lost.
Hey, there's a reason why attorneys are notorious for, I think the numbers were, they were like second or third when it comes down to suicide rates, and I know they have wellness issues because, it's a tough job. And you have clients who, sometimes you have great clients who understand and, understand why you're charging, how much you're charging. And then there's some clients who just think, attorneys should always be perfect. And being perfect is not what's required under the law. But, it's tough on attorneys because if cases were guaranteed, especially in litigation, you wouldn't have trials, right? If you knew the outcome and both sides knew this type of case, this is what we're going to get, there wouldn't be trials. The reason we go to trial is because a jury of your peers, or if it's a bench trial, a judge, will decide the case. And you just never know. So when an attorney makes a decision and it doesn't go in their favor, you're going to have an unhappy client who is going to decide whether or not they want to file a lawsuit.
Right, and they wouldn't be there in the first place fighting it if they didn't think they could win.
Yeah.
So it's tough. And then it doesn't even end sometimes at the trial court. It may go up to the appellate court, and the appellate court flips it over. So,
I've heard of those cases where, you win at the trial level, and then, defense attorneys, like they do, file an appeal, and then it gets overturned. And then you're back to, so we're starting at square one. So, I get what you're saying, man. It's a tough job, and I think clients need to realize that whether you're on the plaintiff side or defense side, this is not easy. But if you have an attorney who just, did something really egregious, well, think about that bar grievance or legal malpractice claim.
Right. Let me ask you something that is near and dear to my heart. Would you consider this malpractice if someone is alleged to have breached a contract and an attorney is representing the person that is alleged to have breached the contract? If that attorney fails to analyze that contract to see if, in fact, his client did breach the contract, is that malpractice?
Well, I'm going to give you a typical law school answer. That depends.
Okay.
Yeah, you see that a lot, and you hear about plaintiffs and plaintiffs' attorneys who are going, listen, if this defense attorney had done his job, we wouldn't have spent 2 years litigating over a breach of contract. That was obviously a breach of contract.
Right.
So, yeah, I mean, that's a situation where attorneys, I think any good attorney is going to analyze what's the allegation that there's a breach, and then speak to their client and say, here's the pros and cons. What do you want to do? I mean, essentially, I mean, if you say, hey, there might be a breach or there is a breach, here are some possible defenses. But, yeah, I think a client has to be very involved in that analysis. Very involved.
But I mean, if the attorney doesn't analyze that transaction, well, let me give you a case in point. You have the Federal Deposit Insurance Corporation. They sent their bank examiners out, and their bank examiners examined a couple hundred or so mortgage transactions. And in those mortgage transactions, they found that 83% of the mortgages had problems, and 76% of the appraisals had problems. And so therefore, you got 83%, 76% added together are problems with these mortgage transactions. Well, my firm, one of the things that we do is we analyze mortgage transactions for homeowners that are in foreclosure to see if, in fact, the bank breached first, there's any statutory regulatory violations, there's any set-offs, there's any recoupment, there's any errors in the contract, or any of those problems. And you have attorneys, and I know this in Florida for a fact, we call them stall attorneys. They've never read the contract, and then here's a homeowner that's being foreclosed on. The bank's alleging that they breached the contract. They failed to make timely payments, therefore we can take the house. And the attorney never has once read that contract. And all they do is say, well, wait a minute, we're going to make a standing argument. You know, did they actually have the note, when they filed the complaint, blah, 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 blah. If they had the note, the house gets foreclosed on. If they didn't have the note, the case gets dismissed. But the bank gets the note, comes back and reforecloses, but the outcome's the same. The homeowner lost their house. My contention is that if a lawyer has failed to analyze that contract, and if he doesn't know how to do it, he should go out and find somebody that does, that if he doesn't do that and that homeowner loses their home, he's committed malpractice.
Well, you bring up a good point about if they don't know what they're doing, they should associate themselves with someone that knows what they're doing, and at the very least, they should be analyzing the facts and know what's in the contract. And that's what's required under the rules governing the Florida bar, right? I mean, every attorney is supposed to be competent in what they're doing. Competency might be a kind of ambiguous word, but I mean, everyone agrees to be competent. I mean, at the very least, you got to look at the facts of the case, analyze the documents. If you don't know what you're doing, you should quickly realize you don't know what you're doing and try and get up to speed as quickly as possible. So, yeah, it might be a situation where if this is obviously analyzing the contract, there was an obvious breach or there wasn't a breach, and the attorney just didn't review the contract, then the client again may want to consider, okay, is this legal malpractice? Because was the attorney giving me competent advice?
Well, we had, for example, we had a client that we did not just one, we've had several that we've done an analysis of their mortgage transaction, and these people lost their house. Their house is gone. And we analyzed their transaction. We found that the bank breached first. They were fraudulently induced into the contract by appraisal fraud and broker fraud. There was statutory regulatory mandates that weren't followed. There was an error in the contract. The legal description was bad on the property. And there was all these problems, and they lost their house. And, that to me, that is ripe for that individual to go after their attorney.
Well, and I want to jump in here though, because in Florida. Yeah, let me explain to Robert. So, as a credit consultant, when the bubble burst, and over the next few years, I used to get lots of phone calls from people. They wanted to buy a house, but they had a house in foreclosure, and they couldn't find an attorney. Now, in the beginning, even I didn't realize this. And I would refer them to attorneys, local attorneys, but what I didn't realize were the attorneys, they were never actually looking at the paperwork. All they were doing was stall tacticking out the case, sometimes for months, sometimes for many years. But in most cases, they didn't actually even read the transaction, the closing transaction. So I actually called, emailed, or mailed over 200 attorneys within a few years. And the responses I got, at least on the phone, were things like, "Hey, I don't want to litigate. I don't want to go to court. I just want to get referrals and charge a monthly fee, a monthly retainer fee. And then at the end, I'll do a loan modification or deed in lieu or whatever, short sale, whatever it comes down to." Do you know I could not find one attorney that would do a counterclaim? Not one.
Wow. Yeah, that is not my area of the law, but I remember when the bubble burst and there was these foreclosure mills. I remember going to court, and it was like a cattle call. I mean, there were just hundreds of attorneys in court trying to get time with the judge, and that looked like a recipe for disaster.
It does, because it was the rocket docket. They were just not listening to anything, that was said, and they just closed them up as quickly as possible. Well, let's do this. We didn't do we'll save the commercial for the end, but let's talk a little bit about that ACAP, that Attorney Consumer Protection, whatever it's called. You know what I'm talking about, the ACAP program that Florida has?
Yeah, the Attorney Consumer Assistance Program.
Thank
ACAP
you.
is what it's called, right? And that's run through the Florida Bar, and they have a hotline. You can Google it, I'm sure, but they'll have a hotline where you can actually call them up and actually explain what's going on and they can tell you, well, yeah, you should probably file a complaint, or I know a lot of times what they tell you is try and work it out with your attorney, because they get a lot of complaints where the attorney is just not responding. And they will step in, actually contact the attorney and say, hey, you have a client who's complaining because you're not responding to them. Speak to your client. Or if there's an issue with a mismanagement of client funds, like, the trust account, there's something wrong with the trust account, the Florida Bar gets in. But what they're trying to do is they're trying to give consumers and clients access to the Florida Bar to discuss some of these issues, because like you said, there's over 100,000 attorneys out there, and hey, you're going to have some that are great and some that are just subpar. So they're trying to give access to discuss these issues.
Do you know what the process is, though? Like, once you file a complaint, then if I remember right, when you file a complaint, does the attorney get a copy of that complaint? So basically, every time you do something to the bar, each party is seeing what the other party, wrote.
Yeah, I mean, I'm not sure exactly how it works, but yes, the attorney is put on notice that there has been a bar complaint, and it's kind of like due process rights. I mean, if there's been a bar complaint, they put the attorney on notice, and they may give the attorney a chance to respond at some point, I guess. But yeah, I mean, on the website, it tells you the entire roadmap of what happens to your complaint. I mean, it goes to someone who reviews it and says, okay, we need more information, or we need some additional documents. It goes to a grievance board who decides if there's probable cause to file an action against this attorney. Then it goes to bar counsel. Bar counsel then files a complaint against the attorney. At that point, the attorney hires an ethical advisor of some sort who can help them through the process. And then it goes all the way to the Supreme Court, because the Florida Supreme Court governs attorneys. So they hear the case. And then the Florida Supreme Court makes a decision as to how to sanction, or how severe the sanction is, or whether there was no claim.
Got it.
Well, I tell you what, we could get Robert a whole lot of clients, because based on what we've found, the work that we've done, because I know that it's an ethics violation alone. Dilatory practices just to stall these foreclosures is an ethics violation, plus realizing any financial or other benefit from improper delay in litigation is not in the interest of the client. And you have attorneys down there that I've spoken with, and I know Laurie's spoken with, that were charging clients upwards of $50,000, and they got foreclosed on. And what they were doing was they were charging an upfront fee of like $3,500, and then they charged $1,000 a month. But the problem is, because of the backlog in the court, once a homeowner missed his first payment until the day that he got booted out of his house, it was 3 years anyway. So, but you had this attorney charging $1,000 a month for 3 or 4 years, and at the end of the day, the outcome was the same. So his stalling tactics not only was an ethics violation, but he was realizing a financial gain that was not in the legitimate interest of the client, and therefore, I think, you're the call, you're the guy.
Keep you busy.
I know.
I think it would keep them awful busy. That's why we tell our clients when we find problems with the transaction, hey, go after your attorney.
Yeah, and I mean there are.
You might not get your house back, but you might get enough money that you wouldn't care.
Yeah, I mean, like I said, I mean there are attorneys that will look at your case and will determine whether it's worth your time to go after an attorney for legal malpractice. I mean, yeah, and there's the ethical violation route. Now the thing is, with ethical violation route, it doesn't put money back in the client's pocket. I mean, I think I may have seen a sanctions where the Supreme Court said you need to pay back your client X amount. But yeah, when it comes on to losing your house or, some type of harm, it's not the ethical violation that gets it done for you. It's a legal malpractice case. And then you need to find an attorney who is willing to take on that legal malpractice case. And, and hey, it's a tough analysis when you're trying to figure out the time, the money, how expensive, that kind of stuff.
Right.
Wow.
Well, look, Robert, why don't you give us your coordinates and give us everything if our listeners would like to contact you, your telephone number, your address, your email, your website, the whole kit and caboodle.
Sure. So, yeah, name is Robert Stines. I'm with the law firm Freeborn and Peters, LLP, and that's just go to freeborn.com. It's spelled just the way it sounds. My email address is rstines, and that's spelled Stines, at freeborn.com. And like most people nowadays, you can find me on Twitter. I'm at Stines Esquire, most of the social media sites.
All right, very good. I think there's a lot of good information, Storm. What'd you think?
Yeah, I mean, I think that not only is he helpful for people that need to get represented, but also people on the other side. You've given them some ideas that you may be wasting your time in certain instances, but in other instances, it's well worth your while to go after these guys if they've harmed you in any way, shape, or form.
Yes, and that's typical in any case, right? I mean, you got to do that analysis. Is it worth your time? Yeah.
Yeah. Well, I want to thank you, Robert, because we're going to have Robert back on another show because he can also discuss another fraud topic. So I'll be scheduling him for that. Thank you. Yeah, we're going to talk about that other topic. So I told Storm a little bit before the show, and we'll set that up. And I want to thank our audience, for listening, to the show today. So if you're going to join us again, it's going to be next Monday, same time, 1 to 2 p.m. Eastern Time, live for Fraudsters Radio. Remember, we do want to hear your stories, and you can contact us through the Fraudsters Radio Facebook page. Thanks very much, guys. Great show.
Okay, guys. Enjoy your week.
Okay, bye-bye.
Bye-bye.
Okay.
Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed.